Good afternoon and welcome. We are here for oral argument on the redistricting principles and preliminary issues in the special redistricting panel matters. As you're aware from the order and probably some instructions you've received earlier this afternoon, each party will have 15 minutes for their argument in chief. I will just remind you that the panel members are well familiar with your written submissions, and after a minute or so, we will likely jump in and start having a discussion with you on the arguments you are making. You will each have 5 minutes for rebuttal. I think you've also received instruction about the covers that go over the microphone, and I'll just warn you that they make noise when you put them on and take them off. Don't worry, we're not offended by that noise, it just is what it is. The timing is indicated by the lights at the podium, and you know that. The only other comment I would make as a preliminary matter would ask you to please state your name and identify the parties you represent when you begin your argument. You will be presenting argument as we indicated in our order, in the order in which your party is listed on the caption. And so that means we will start with counsel for the Watson plaintiffs with argument first. Here we go.
Good afternoon, Your Honors. May it please the court, counsel. My name is Adam Sinkowski. With me is James H. Gilbert and Jody Nalofsky from the James H. Gilbert Law Group. And we represent the plaintiffs Peter Watson, Joseph Mansky, Nancy Greenwood, Mary Cupper, Douglas Backstrom, James Hugas III, and the League of Women Voters Minnesota. The Watson plaintiffs are before the court today seeking transparency in the submissions of redistricting maps by the parties. The Anderson plaintiffs and the Sachs plaintiffs intervened and joined this litigation on behalf of political parties. They admitted in their pleadings. The Anderson plaintiffs state that each plaintiff in intervention is Republican and/or a member or supporter of the Republican Party of Minnesota and seeks to advance the interests of Republicans in Minnesota in this action. The Anderson plaintiffs say that they intend to advocate and vote for DFL candidates. The Watson plaintiffs are not here on behalf of a political party, despite allegations to the contrary. And it is no surprise that these political parties do not want this panel to see the partisan effect of their maps. Whether the parties want to admit it or not, with Maptitude technology, the Anderson plaintiffs and the Sachs plaintiffs and all the parties have access to high-tech software that will allow them to draw highly partisan maps while still complying with the redistricting principles ordered by this panel.
So I want to move us along, and I appreciate your comments regarding your politics of it. But unlike the other parties, the Watson plaintiffs are asking us to renumber the legislative districts. And instead of bypassing and going into the metropolitan council or 11 counties, what is your client, what is the ill that your client is trying to correct or cure by renumbering the districts?
Well, I think there's a couple of ills that we're trying to correct here. One is that anytime there is a change made to the Twin Cities mapping, such as growing from 11 counties to 11 counties, like they did 10 years ago, basically everything south of St. Cloud is renumbered. It blows up the whole system, really, for lack of a better phrase. And that will not happen if we just number from the northwest to the southeast. We can change the amount of counties that are in the Twin Cities area from 9 to 11 to 13 to 7. And if the numbers go northeast to south or northwest to southeast, those types of changes will not change materially the numbers of districts. And in 10 years ago in Hippert, when they did expand the metro area. For example, Washington County went from the mid to high 50s to the high 30s, and just by making that one change. And we can just we can put this behind us forever if we can just go back to a regular series like we had in this state from 1897 until 1972. Well, the numbering system was put in place by a court, so I think they do have that authority. It was put in place in 1972, and these districts were always numbered prior to the court intervention in a regular series from the northwest to the southeast. You're welcome. Going back to the partisanship issues, none of the parties have pointed to any law prohibiting consideration of partisan data. And again, where two parties expressly state they are here to advance the interests of a political party, I think this panel deserves to know how much they are trying to advance those interests. And if there is a principle that does not—
Counsel, the question I have on that is, throughout the public hearings, this panel was repeatedly told to not look at politics, that this should be an apolitical process. And it seems to me by injecting partisan evaluation, asking us to look at measures of competitiveness and partisanship, that you're inviting us to do exactly what members of the public have said we should not do. Could you respond to that?
Yeah, so I think when the Democratic Party and the Republican Party intervened and joined into this lawsuit, I think that injected politics into it, and I don't think there's any way to avoid it. I mean, they're here for a reason. And I understand that the panel would not want to consider those types of issues, but where a party has come here and admitted in their pleadings that we are here to benefit a party, I just don't think that can be ignored. And it's uncomfortable, and I understand why a panel would not want to get into it, but I don't see how we can ignore, I guess, that elephant in the room.
Counsel, as a follow-up to that, tell us, is there a benefit of including shared political interests in the definition then of community of interest? And if there is a benefit, what it is?
Well, we excluded shared political interests and community of interest in our principle, and I think that is because we created the partisan principle. Is there a benefit to that? I think that that's a great question. I don't think that's going to do enough. I think with community of interest, when parties are discussing communities of interest, they're discussing them in terms of small, compact communities, and they're not discussing them more in terms of a statewide influence. And honestly, that's what this is about. I mean, these reports that this court would be looking at would be really statewide election results. And by looking at small subgroups of political party affiliation around the state, I don't think that's going to have a material impact. So I don't think that's going to get us where we need to go.
Counsel, just one more question along those lines. What authority permits the panel to draw political lines based on any political considerations?
Well, we saw some cases cited by the parties like Rucho, Whitford, Vaith, which I'm sure you're familiar with, and those cases do not allow a court to consider the constitutionality of a map. That's not what we're asking this court to do. There's no constitutional test for political subdivision lines, compactness, communities of interest, incumbency, but we still consider those issues. And I don't think there's anything that I've seen out there that prevents this panel from considering this. We're not asking to test the constitutionality, we're just asking the panel to consider it as a redistricting criteria, and we have subordinated it to all other criteria, which I think is important.
All right, just one follow-up on that. Is it sufficient simply not to purposely favor or disfavor any political party when drawing the lines? Is that enough, or do we have to have some underlying understanding of what the political interests are?
Well, the goal is not to favor a party. I think the only way you can do that is with data. And so I don't know how we could do that. I think a redistricting criteria, ordering the parties to not unduly favor a party would be a good start and is important. I think you have to have that. But, how can you enforce that without data? So I think you have to kind of, look under the tent. I don't see another way to really, to accomplish it. Excuse me, I gotta grab some water here. And, there's probably some questions from the panel about the practicality of what we're actually trying to do here. How are we going to do this? So just kind of getting into that, what are we asking this panel to do? We're asking this panel to prevent undue bias. We're not asking for fairness. We're not asking the panel to say, if a party wins 60% of the vote, they should win 60% of the seats. Our test is just to say, make it more likely than not, or a reasonable likelihood that the party that receives the most votes is more likely to get the more seats. It's a pass-fail test. It's not a proportionality test, and it's not a guarantee. We would never expect that a court could guarantee anything like that, but it provides the court with some framework. And, I think it was the Sachs plaintiffs that mentioned about, how is the panel going to draw a map first with an eye first towards considering political, affiliation, because that would be challenging. And we get that. And practically how we see this looking is the panel draws a map with statutory and constitutional principles, and then they run their partisanship report. And then they look at the report that they've run, they look at what the parties have, and they can kind of see where is the range here? Where's the range of reasonableness? And that's kind of practically speaking how we see this all being accomplished by this panel. And I think the Watson plaintiff's ranking system reflects this approach of draw first, assess afterwards. And if the panel does not want to adopt the Watson plaintiff's ranking system, a way that they could account for this, after the fact look at partisanship would be to use a criteria similar to incumbency by stating that partisanship is a factor subordinate to all other redistricting criteria. And that would allow it to draw the map and look at it afterwards and just make sure that nothing has been drawn that is overly partisan in one way or the other.
Council, I'd like to draw your attention to a slightly different topic. So you urge latitude on congressional population equality because of subdivisions and differential privacy. There are a lot of questions I have about that, but one in particular is that the parties in this case have agreed that the 2020 census data is the correct data for this panel to use for redistricting. So isn't differential privacy just part of that data?
I agree with that. I think that differential privacy alone is not a sufficient reason to have a congressional population deviation. I guess that was just one example that we were trying to make of that. The population's not perfect, but I think the Supreme Court at the United States Supreme Court has made clear that that's not enough. And we're not here saying that that is enough. But what we are saying is that we believe that there are sufficient reasons that could justify it. And we just want the opportunity to make that showing. And if this panel looks at what we've done and does not think we've made that showing, they have full discretion to draw a map that has a population deviation of ±1, but we feel that decisions should be made with a full record as opposed to making it at the stage of establishing redistricting criteria. With respect to
Council, before you move on,
subdivisions,
before you move on to your next point, the Sachs and Corey plaintiffs argue in favor of a principle that requires districts to provide racial, ethnic, or language minority groups equal opportunity to elect a candidate of choice alone or in coalition with others, and if possible, to create districts that provide such groups the opportunity to influence the outcome of an election. You've seen those principles, or they're proposed, yes?
Yes, I have.
Do you agree with them?
I agree. The Watson plaintiffs are strong proponents of increasing minority representation in the legislature. I believe the Anderson plaintiffs said that we don't need to move community, or that minority representation has improved in the last 2 redistricting cycles. Well, it's still not where it needs to be. I think the Corey plaintiffs said that it's 12%, and I think their share of population is 23%. So, as far as the language used by the Sachs and the Anderson plaintiffs, I don't know if I could stand here today, quite honestly, and say specifically whether each phrase and word I agree or disagree with it. But I think as far as minority representation, I will stand here today and say we support it, and we think that minorities are not adequately represented within the legislature.
Are there any shared interests that should not be considered in identifying communities of interest?
I cannot think of any off the top. Well, we put that political affiliation, incumbency, and partisanship should not be considered, but that's more because we put them in a principle below that. So, but I think that's a case-by-case determination by the court based on the facts that are presented with the parties' redistricting maps.
You just made mention of a principle being ranked below other principles. Are you advocating that we have a hierarchy of redistricting principles, and if so, what's the basis for your argument, and what would that be?
We do advocate for a hierarchy, and the basis for it is the Constitution controls. So we would have the constitutional principles rank above all else, and then we move to the statutory principles, and then we move to the more traditional redistricting principles, compactness, political subdivision, statutory in Minnesota, but compactness and some of the other ones, and communities of interest. And then move down to partisanship and competition. So really, it's a constitutional, statutory, traditional, partisan we think it's important because there should be some sort of this panel should put more weight with things such as population equality and following our Constitution because I really, quite frankly, don't think there's any leeway not to. So,
is your argument that Indian reservations can be split for reasons of convenience or contiguity? That means that convenience and contiguity are more important than preserving American Indian reservations?
I certainly don't think they're more important, but I think because they are constitutional requirements, I think we have to follow our Constitution.
Counsel, before you move on, I have a question, and I'm going to ask this to all the other parties, so heads up. What is the most important change that you would like this panel to do from previous panels?
Partisanship. Absolutely, 100%. We believe that with the technology available to these parties, drawing maps that comply with the principles that this panel is going to order in a way that benefits a political party is not difficult. And we think the only way that this panel can stop that, quite frankly, is to have a principle that tells these parties not to unduly bias any political party and to have data that will be submitted by all the parties that will open the doors to all the parties' maps, not just one party, so this panel can just make sure that they haven't done that.
So that goes to the concept of compactness, right? The idea that we don't want to shape all these districts in a funny fashion, right?
Well, I don't think so. I think compactness is a measure that is used to identify gerrymanders. So I think, it has been used by courts as a way to identify racial gerrymanders, partisan gerrymanders, but you can still have compact districts and still have maps that favor political parties. So I think this goes one step further because I don't think compactness in and of itself is enough to prevent parties drawing maps that favor their own political parties. I think I'm out of time.
I think you are. You will have 5 minutes for rebuttal.
Thank you, Your Honors.
Thank you. We will next hear from counsel for the Anderson plaintiffs.
May it please the court, my name is Elizabeth Braum. I'm with the law firm of Taft, Stettinius, and Hollister, and I am here today representing the Anderson plaintiffs, which consist of Paul Anderson, Ida Leno, Chuck Brusvin, Karen Lane, Joel Heineman, Carol Wagner, and Daniel Schoenhardt. 10 years ago, and 10 years ago again before that, Minnesota special redistricting panels were able to adopt criteria and adopt maps that were widely lauded as impartial, fair, and even-handed on behalf of the citizens of the state of Minnesota. They did that on the basis of neutral, objective redistricting criteria that complied with, in the case of 10 years ago, the work of the panel before that, and also longstanding precedent from the United States Supreme Court. No party at any point in their briefing has offered any criticism or evidence to show that using this criteria in the past has resulted in unfair maps or a problem that needed to be corrected. And I'll note in saying that just as in this case, in those prior cases, there was no secret who the parties involved represented and what their interests were. There were political parties represented, in some cases, as here, by multiple different parties within the proceeding. And even so, the panels were able to adopt maps that were fair and impartial and served this state well. And, in fact, resulted in districts, both legislative and congressional, that have changed hands many times within the course of each decade. And so, again, there's no issue either with competition as well as fairness.
So, Council, that's my question. You teed it up quite nicely. What's the most important change that this panel can look at as opposed to the previous panels that the courts have done?
It's the Anderson plaintiff's view that the panel really doesn't need to change its criteria at all, frankly. And that's not because there is some particular political outcome that we believe we can achieve with that criteria. It is because the panels have adopted criteria that has been fair and even-handed. And frankly, my clients are most concerned with protecting changes that go too far away from what has worked well in the past.
Thank you.
Counsel, I think every other party in this case urges the panel to place the criteria of compactness far lower in the hierarchy, to the extent there's a formal hierarchy of redistricting principles. And I think your clients are alone in arguing that should still be considered along with convenience and contiguity. Why are you right and the rest of the parties are wrong about that?
Well, a couple of things I think are at play here. First of all, we again are going by precedent in the state of Minnesota, and historically the Zachman case and the Hippert case both resulted in criteria that said convenient, compact, contiguous. I may have my order wrong there, but those are how the districts were to be drawn. And so we again are going in part by that. We are also continuing to advocate for compactness in the way it's been treated in the past, because the United States Supreme Court, Minnesota courts have repeatedly said that it is a test and a way of looking at whether districts are fair, whether they're being gerrymandered. And so it serves a very particular purpose in that regard, just as convenience and contiguity do. The other thing I'll say is that it seems to me that part of the goal of reducing the value of compactness is to allow more maneuvering by certain parties in order to draw districts that are either serving a particular goal. I'm not here to say what that goal might be. I haven't seen their maps yet. But the less high on the priority list compactness is ranked, the easier it is to try and change districts to make them more competitive or to make them more proportional and to achieve other goals that may or may not ultimately be represented in the evidence. And so it's our view that the principles should be focused on these neutral and objective redistricting criteria for the good of the state as a whole.
Along those lines, Council, you just used the word objective. So I'm curious as to, in your response, you talk about communities of interest being a subjective factor, yes?
Mm-hmm. It is certainly, in our view, a more subjective factor than others. But that's not to say there can't be evidence that would support a community of interest as existing.
Why does subjectivity make community of interest a lower priority?
Because it's more prone to manipulation. A political subdivision is easily identifiable on a map. It's a legal boundary. It's a place that we heard over and over again in the public hearings the citizens of Minnesota identify with. A community of interest is not only less readily identifiable, but it can be defined in multiple ways that might overlap and conflict with each other. So someone might consider, for example, their neighborhood a community of interest. They might also consider that they have interest in a particular lake or passage or road or something along those lines. They might have socioeconomic interests, and it becomes a much harder thing to say which community of interest should be elevated again or in relation to a different community of interest in order to achieve an ultimately fair and objective map.
But counsel, don't you agree that courts routinely make decisions based on subjective evidence?
I don't disagree with that at all. I think, though, that what we see in the context of redistricting is that the United States Supreme Court, past Minnesota panels have repeatedly said it is in the best interest of the citizens, it best serves the one person, one vote principle to minimize the extent to which that's necessary in redistricting and to follow objective neutral criteria first, so that the maps then, as additional decisions need to be made, those subjective determinations are reduced at the end of the day. They'll never go away. I don't disagree with that at all.
Council, just in relationship to convenience in a district, has the term convenience had any change over the years now that we're in an electronic age, whether it's voting or banking? What does convenient mean?
Convenience is, I think, a term that fundamentally has not changed. How it might be implemented, of course, there are going to be changes in the way we talked about, a moment, roads. You know, when better roads make it easier for people to get to polling booths and make it easier for representatives to achieve or to get across their district. Those kinds of things, I think, continue to be the same regardless of technology. And voting is fundamentally the same. Obviously, there are more opportunities for voting absentee and things like that. That's all fine. But at the end of the day, the convenience in the context of redistricting is about making sure that districts can be traversed by both the citizens and the people who represent them, and that it, again, is a measure of what looks like an objective district, or the objectively drawn district, as opposed to one that snakes up into a different part of the state or has other features like that.
And as long as I have your attention, the Watson plaintiffs have talked about renumbering the districts. Do you believe that that's necessary?
I do not, and my clients do not. And the reason is the United States Supreme Court has repeatedly said, and this goes for a lot of the different arguments that we're making in this proceeding, that when the courts are redrawing maps, the role is much more limited than when the legislature draws maps. And when it comes to numbering of districts, understanding how that came to be, that numbering has largely been the same for decades. It has evolved somewhat. And so we don't see a reason why this panel should go out on a limb, as it were, and renumber just for the sake of renumbering, particularly when there's no evidence in this record of actual voter confusion that has resulted from the numbering as it currently exists.
So, Ms. Braum, let me follow up on that. You made reference to the court's limited role where the legislature has drawn the lines, but I think, as argued by the Watson's attorney, when it comes to numbering, that numbering system, the bypass, was actually adopted during court redistricting. Does that affect your analysis?
It really doesn't, and the reason is, there are a couple of reasons. First of all, the maps have always been drawn in Minnesota by courts. And so I suppose that the legislature could offer a change to numbering, and it would probably be in their province to do so. But at this time, without evidence that there's a need to deviate from what has worked well in the past, we don't think it makes sense for the panel to do that, particularly when the panel, at the end of the day, is not judging particular maps or is not.
So, but if I could just respond for a quick second to make sure I'm understanding your argument. It sounds now as though you're arguing renumbering shouldn't happen because it's not common sense for the court to take that. There's no reason, no harm, which is a different argument from what I heard you say earlier. Okay. You suggested it was that the court had a limited role and perhaps didn't have authority to renumber.
To be clear, I didn't mean to change what I was saying before, which was that the court's role is somewhat limited in redistricting whether courts are drawing maps or judging maps drawn by others. But particularly when the court is drawing maps, its role is more limited. And in addition to that, we believe it is common sense, I think, as well, that where a panel is looking at maps that have worked well for 10 and 20 years and at processes that have worked well, to undertake a wholesale renumbering in that context just isn't necessary. If the legislature felt that it was important to renumber the districts, that's something that in theory if they could reach agreement on anything, that might be something that could be reached agreement through statute and not by the court. We just don't feel that it's necessary given the court's limited role for the court to do that here.
You've made many mentions about the court's limited role, and I think you maybe among the parties are solely arguing for a least change or advocating for a least change approach to this panel's work. I just wanted to make sure I understand what you mean by least change approach. Are we talking about redistricting principles themselves, maps down the road? Obviously, they're going to be changed because the population has changed, so lines will be changing. So if you could flesh out a little bit more for me what you mean by a least change approach, I'd appreciate it.
Certainly. My client's view is that right now, of course, we are in the principal stage, and so that's specifically what we're talking about at this time. We haven't gone beyond that to say whether or not the maps themselves should be least change or what that will mean, because we haven't gotten to the point of drawing maps. We need to know what the principles are to guide that process. So in this context, we are focused on what the principles should look like. And the reason, and I think we wouldn't be advocating for a least changes approach if there was evidence or reason that what the panel had done in the past with respect to principles was not working. And we just don't have that evidence here. And given we have Minnesota Supreme Court decisions outside of redistricting that talk about the value of courts honoring past precedent, that those similar types of issues arise here. And I want to touch on real briefly, in that same vein, the question about, well, should partisan data should become a part of the panel's consideration here? And I think it's important to underscore that nothing that's being offered here with respect to partisan data or the availability of partisan data is truly new. The technology gets slightly better, but 20 years ago, partisan data was available. The panel specifically decided not to consider it, or at least not to include it as a criteria or a principle, which is a different thing than saying parties can't point to each other as making maps that are overly partisan. Our position is that the partisan data need not be a criteria, because the panels in the past have been able to do very well with maps without adopting that criteria. The facts will be what they will be. And on top of that, if there was an adoption of a partisanship as a criteria, whether it's competitiveness, proportionality, something, whatever the data might look like, that's going to create a zoom focus on that criteria in any evaluation of whether the panel's maps are fair or not. And our clients would much prefer to see maps that are generally understood to be fair and based on neutral redistricting criteria as they have been in the past.
You advocate that we should include in communities of interest groups of people with shared political interests. And I know that the last redistricting panel had that included in its definition of communities of interest. If that is true, if you believe this panel should evaluate that as part of our communities of interest analysis, wouldn't the partisan data be helpful?
So to be clear, what we are advocating is that communities of interest be defined broadly. We are not necessarily advocating that any particular type of community of interest absolutely be evaluated as a separate part of the panel's decision or memorandum. What we are saying is that communities of interest can be defined many, many different ways. That is one way. If someone wants to make the argument that a community of interest exists because of political data or any other type of data, we're not foreclosing them from making that argument. We are just suggesting that that in general, the communities of interest, because it can be subjectively determined, should be based on, or should not foreclose any particular kind of community of interest at this stage.
So counsel, is there a benefit then to including shared political interest in the definition of community of interest? And if there is a benefit, what is it?
I see no benefit, because it would potentially, any community of interest that's identified in the panel's criteria will, I suspect, be automatically viewed as superior to any community of interest that is not specifically identified. And that is something that we would like to see avoided in this stage of the process, because we don't have all the evidence yet. We don't know what the maps will look like. To the question of whether there is a benefit to having that be included, we don't think there is. Again, it elevates the idea of partisanship above the idea of other communities of interest. And again, we're not saying that parties can't point to each other and complain that our maps are partisan, or we can't claim that their maps are partisan. That's not what we're suggesting here. What we're suggesting is that as a principle, that's not something that the panel should elevate to that level of a baseline item on which you're going to judge any particular map.
Madam Presiding Judge, may I ask one more question? Along those same lines then, are there any shared interests that should not be considered in identifying community of interest, in your client's opinion?
At this point, there's nothing that we would explicitly rule out. There may come a time in map making when we'll see someone come up with a community of interest that surprises us or that we cannot see any evidence to support, and we might at that time say, this is not the type of community of interest that is either supported in the evidence or that makes sense or that seems fair and appropriate. So I'm not saying that anything that a party might put out there would be considered acceptable. It's just at this point, our view is that the panel should define the communities of interest as panels in Minnesota have for the last 20 years, resulting in successful outcomes. Thank you.
Thank you. We will next hear from Secretary of State Steve Simon.
I apologize, but this came off with, I think we're okay.
You may proceed.
Thank you. Good afternoon. May it please the court, I'm Angela Behrens on behalf of Secretary of State Steve Simon. Historically, the Secretary of State has had a rather limited role in redistricting litigation, and consistent with the approach of past secretaries, Secretary Simon does not intend to submit a specific map for the panel's consideration, but he has offered principles that he believes should guide the parties and the panel in creating the map. And his list of principles are presented because he believes they best serve the goal of equal representation. And they do largely track what the panel did in Hippert with a few modifications. And what I'd like to address today is that I believe his proposed modifications are a bit more modest than some of the parties have suggested, because they have really been embraced by the analysis and outcome in Hippert and in past cases, even if they weren't explicitly listed in the principles. So what he's really asking this panel to do is make explicit what has been implicit in some of the past decisions. I won't dwell much on not dividing sovereign tribal lands. There seems to be consensus across the parties that that is appropriate. That was emphasized in the Hippert decisions as well, that it was important to preserve those lands.
So, Council, since you're touching on it briefly, let me just follow up. So you join American Indian reservations as a political subdivision and embrace the shall not divide concept, which, as you said, seems to be shared by most of the parties. But how does this panel square that with case law that has held that the reservations and the tribes in particular have inherent sovereign authority? A political subdivision doesn't have sovereign authority. So could you address that?
Certainly. I think it really goes to what the focus of this redistricting process is, which is equal representation in Minnesota elections. And the members of the sovereign nations are still voting members of the Minnesota population. So there's not a real substantive reason to treat them differently than political subdivisions. And for the same reason, we try to preserve counties and cities and townships whenever possible. Sovereign nations should be treated the same. And that's why it seems most appropriate to fit that with the political subdivision principle.
Council, I have a question. I'm going to interrupt again. So you agree that we should respect the boundaries of the American Indian reservations of this state, yes?
Yes.
Why shouldn't we just state that as a redistricting principle then?
The panel can, and I think where the parties, I wouldn't even call it disagreement, it's just perhaps quibbling and wording and placement. Some have separated that into a specific principle. The panel could, what I think the panel should ultimately do is somewhere recognize that as a specific principle, because it is consistent with what the panels have done in the past, and it provides those nations the express respect that is warranted in this process. The other two modifications that the Secretary has proposed to the Hibbert principles relate to political neutrality and electoral competitiveness. These are somewhat related because they both go to serving that purpose. The overarching purpose of redistricting is equal representation and giving meaning to the concept of one person, one vote.
Counsel, along those lines, when you talk about equal representation, the Sachs and Corey plaintiffs argue in favor of a principle that requires districts to provide racial, ethnic, and language minority groups the opportunity to elect a candidate of their choice. I just asked one of your opposing counsel this question. My question to you is, do you agree with those particular principles? It's either alone or in coalition with others. And if possible, to create the district in such a way that gives these groups the opportunity to influence the outcome of an election. Sounds like maybe you agree with that. Do you agree with that?
Yes. And again, I think some of these principles, the parties largely coalesce around the same concept and they're driving towards the same thing, so the secretary wouldn't oppose some of the proposed tweaks in wording as long as that overarching purpose of equal representation is fulfilled. And it may be framing things as a community of interest or an explicit principle, but they're all driving towards the same outcome. And in Hippert, again, even though political neutrality and competitiveness weren't listed as principles, the end of the panel's decisions in both of those cases ended on a very strong note where the court recognized the whole purpose of this is equal voting power and that districts should not be drawn to benefit legislators or parties, and we want to ensure that people are picking their representatives and not the other way around.
And yet the Hippert panel did not consider the sort of electoral competitiveness, partisan fairness data that I think the secretary at least implicitly supports, and that some of the parties are asking this court to request of the parties as they submit their proposed redistricting plans or maps. It just seems like that's a stretch from where we've been, and that the last panel, as a check at the end, looked at whether incumbents were being favored or disfavored. Why isn't that enough to assure the political fairness or even-handedness as it was 10 years ago?
They're closely related, and I agree with the Watson plaintiffs in the sense that what the secretary is asking for is not that this be priority number one as setting out the map. It is a check on the after as the map has drawn. And it's just expanding that principle of incumbents a bit broader to recognize, as Hippert stated, that the maps aren't being drawn to favor anyone. So it's not just necessarily incumbent candidates, it's any party. And I presume the panel approaches this apolitically, so it may be more of just a statement for public confidence that the public can look to, because regardless of this, whether this is stated as a principle, I think we're all well aware the first thing people will do is analyze whatever map the party creates and perhaps try to look at who it favors or not. And adding it as a principle may also provide a check on the parties as they're submitting their maps, because they will have to show that their map adheres to that principle. And in the public hearings, across, I believe, almost all of the public hearings this panel has heard, they repeatedly heard those themes of voters want fairness. They do not want a partisan map being drawn. They want to have trust in the map that is drawn, and they want to feel that their vote matters. So when they show up, they have a chance of their candidate winning. And the panel also heard testimony that the panel has done a nice job with having competitive districts, and voters value that. That was particularly heard from some of the East Metro suburbs and the 1st Congressional District. So the Hippert panel was achieving these outcomes, and what the secretary believes is appropriate to just acknowledge that as a principle, that is a value that is appropriate in redistricting. At the same time, the secretary has proposed a priority list. These are subordinate, certainly to the extent the panel is going to have to make decisions in drawing boundaries, and not all principles can be respected. Certainly some are more important, preserving the political subdivisions, communities of interest. Those are more likely to achieve that equal representation goal. And that's also why the secretary has proposed pulling out compactness. It is certainly still a factor and it can be helpful, but it's not constitutionally or statutorily required. In Zachman, the panel included a footnote that acknowledged the debates about the limited utility And in Hippert, the court also acknowledged in the legislative plan that not all of the borders were necessarily going to be neat and tidy. So occasionally there may have to be an odd-shaped district, and I assume any very crazily shaped district would get a lot of scrutiny. So it certainly is still a factor.
And I was going to ask you about compactness, and I probably have this question for everyone. Is compactness a goal in and of itself, or is it a check on partisan gerrymandering during some other kind of manipulation of a district?
Perhaps both. It's related in terms of contiguous and convenient territory as well. Compactness is naturally going to be a byproduct of some of those other principles, but it also does serve as a check of looking at the intent, and if something is drawn in a way that just doesn't make sense, that may suggest an ill motive for the court to take a closer look at.
And are there particular measures, I mean, I think Maptitude has 11, if I'm correct, or so, measures of compactness. Some members of the public argue that they are duplicative and that this panel would be wise to select from among 11 if we're going to use compactness measures at all. What do you advocate in terms of particular 4 or 5 tests that would be the most effective, meaningful measure of compactness?
I don't know that the Secretary has taken a position on that I can present to the court today. But certainly if the panel wants different measures of compactness, that might be something it could ask for in once it sets the principles and some of the parameters for the maps.
Council, just back on political subdivisions, when it is necessary to divide political subdivisions, recognizing that could be school districts, could be many different type of entities, is there an order of priority of which political subdivisions should be divided first, or at all costs preserved, right down to 6 square mile townships? Is there any priority of subdivisions?
I don't believe so. The court will have to make some tough decisions, but I certainly don't want to say one political subdivision is more important than the others. Unless there are no further questions, I'd ask that.
Actually, I just have one more question then, if we've got another minute or two, and that is, we talked a little bit about political considerations, and I'd also ask you, just what authority permits or would require the panel to draw any lines based on any kind of political consideration?
I don't know that there's anything that prohibits it. The panel has some latitude, and obviously being mindful that it is a judicial body and not a legislative body. I'd highlight that the principles, as has been addressed in some of the briefings, they have not been static over the years. There have been tweaks here and there. There are some that are constitutionally and statutorily required, but the panels have made changes over the time, and those have been produced good maps. So there is some discretion there.
That we have some tough decisions, as you had indicated, but if the Secretary talks about competitiveness, how do we do that without giving some deference to political considerations?
I'm sorry, could you repeat the question?
Well, I'm just saying the Secretary in the filings indicated competitiveness is good in the districts. How do we give deference to competitiveness if we're not going to give consideration to underlying political?
Again, I think it's a check on the impact of the map that is drawn, and that's why the Secretary has proposed a priority. It is near the end. The Watson plaintiff's brief outlined there are some measures that the legislature has used as well in evaluating maps. So I think it's just looking at the data and to the extent it's possible or something has wildly changed from the past that might warrant closer scrutiny. And in some cases, it may be inevitable. Thank you.
Counsel, does the Secretary believe that there is a benefit to including political interest in the definition of community of interest?
I don't believe there should be, because the community of interest factor or principle goes to preserving communities of interest. So if putting it in there would be about more preserving political power, and I think consistent with his other principles of looking for political neutrality, they're slightly pointed in slightly different ways.
Do you think there's any shared interest that should not be considered in identifying communities of interest?
No, and the panels have historically defined that as including but not limited to, and as some of the other parties have said, I think it'll be incumbent upon any party advocating for a community of interest to define that and explain why it is a community of interest. Unless there are no further questions, I respectfully ask that the panel adopt the Secretary's principles.
Thank you, Counsel. And we will next hear from the Sachs plaintiffs.
Good afternoon, Your Honors, and may it please the panel, my name is Jonathan Hawley. I'm from Elias Law Group, and I represent the Sachs plaintiffs. As an introductory matter, I think it's appropriate that we began the hearing today hearing from the Watson plaintiffs and the Anderson plaintiffs, because I think in a lot of ways they sort of occupy two poles on the issues of redistricting principles and indeed how the panel should undertake its redistricting responsibilities. On one hand, we have the Anderson plaintiffs who have pursued the most constrictive and inflexible approach of the various parties in this matter, not only in terms of the principles, but in how those principles should be applied. Now, as a judicial redistricting body, I don't think anyone here denies that the panel is obliged to take a restrained and prudent approach to redistricting. But at the same time, a calcified approach for its own sake might not be the best option, especially since some marginal changes can be made to the redistricting principles, not only to ensure fair representation for all Minnesotans, but also to bring this panel's deliberations into closer conformity with what both the Hippert and the Zachman panels ultimately did when they were undertaking their redistricting. On the other hand, we have the Watson plaintiffs, and they've proposed a number of significant departures in terms of methodology and focus. And that's problematic as well, I think, for two reasons. The first is that by their own admission, some of their proposals are untested and I would suggest even at times controversial, especially the issues of partisanship and competitiveness. They are introducing new ideas that, however well-intentioned they might be, are perhaps better left to legislative deliberation or academic debate rather than this panel's redistricting efforts. And also, moreover...
So, Counsel, then what is our check? Again, the public hearings were full of people saying, keep politics out of this, make this fair, make sure the redistricting does not favor one political party over another. How do we know we're achieving that if we don't consider data that's readily available?
I think following the example of the Hippert and the Zachman panels is an excellent way of doing that, Your Honor. I don't think there's any argument that the plans that the panel adopted 10 years ago fairly and accurately reflected the political makeup of this state. And unlike certain other states around the country right now, Minnesota has not been plagued by the sort of partisan gamesmanship that the Watson plaintiffs in particular seemed intent on combating. It's just not an issue here, and I think it's because the Hippert panel, the Zachman panel, and previous judicial redistricting bodies considered neutral redistricting criteria, undertook public and transparent hearings, and the result was an impartial and fair map. So again, I think the proof is in the pudding here. By adopting neutral criteria as previous panels have done, and by diligently and thoughtfully applying them, I think the result will be an impartial map that this panel can reach without wading into murky political waters that are both untested and perhaps not within the purview of judicial redistricting.
So, Counsel, let me ask you a threshold question. I think you are alone in advocating that the districts are currently unconstitutional. And there's been briefing from other parties that have suggested that that issue is not yet ripe. And in fact, that was the decision of the Hippert panel in a similar scenario. So would you address that?
Yes, our position is that the districts are currently malapportioned. Now, obviously, there is case law suggesting that population variations that occur naturally over the course of a decade following redistricting do not automatically render the previous map unconstitutional. However, it is our position that by April 26th, the date that we filed our petition, the census data had been released demonstrating that the current congressional and state legislative maps in Minnesota are malapportioned. It's our position that at that point, is when we had proof of that, at that point, the constitutional injury began. This is sort of an interesting legal puzzle in the sense that most of the time when we were assessing constitutionality, it involves state action. This is a case where, because of the requirements of redistricting, it is government inaction that leads to the constitutional violation. That's kind of unique and a bit unusual, and so the parameters of it might be a bit murky, but I don't think there's any doubt, number one, that this panel has jurisdiction to undertake judicial redistricting as previous panels have done. And by the time, based on the schedule that the panel has adopted, it becomes time to adopt those plans. Legislative impasse will have occurred, and I don't think there will be any doubt about both the constitutional injury at that point and the inevitability of impasse and the need for judicial intervention.
So address the legislature's authority, though, to adopt maps until February 15th.
Yes, in the first instance, the authority, constitutional otherwise, of redistricting lies with the legislative authority. I think the reason that we're all here is just based on historic practice and what's happened for the past many decades. When there is divided government of the sort that there currently is in this state, judicial intervention is needed. But as an overarching matter, it is still the kind of legislative grace to take the first crack at redistricting. In the event that there is impasse, then it will fall to this judicial panel to undertake that.
Thank you.
I'd like to touch a little bit more on the issues of partisanship and competitiveness, and particularly the principles that have been advanced by both the Watson plaintiffs and the Secretary of State. And there have been questions about whether or not injecting politics and partisanship into this panel's deliberation might have the effect of undermining its efforts. And I think the Sachs plaintiffs would say that that is indeed a risk. And there are a couple of specific points I'd like to touch on. The first is that what might be viewed as partisan effects might actually be the inevitable side effects of other neutral and desirable redistricting phenomena. For example, communities of interest, which all of the parties here believe should be preserved and protected to some extent. People who form those communities of interest might share political views, or members of minority groups might coalesce around similar candidates. There are partisan and political side effects to the inevitable sorting and grouping of people, and by adopting a competitiveness principle in particular, there's a risk that those sorts of communities of interest that would otherwise be protected might inadvertently be broken up, only to satisfy what's essentially an arbitrary percentage benchmark of competitiveness.
So, counsel, do you believe that there is a benefit to including political interest in the definition of communities of interest?
I think the Sachs plaintiffs share the views expressed by the previous parties here, which is that there is a risk to including political communities of interest in that principle. As counsel for the secretary noted, if the idea of communities of interest is about empowering communities rather than reinforcing the politics and the structures already in power, then it is an inappropriate metric. And I don't think there is much benefit to including it either, because whatever partisan unities might occur in communities of people, those will likely be reflected in nonpartisan, neutral factors, social, ethnic, cultural, socioeconomic, occupational, the sorts of communities of interest that the Sachs plaintiffs suggest should be enumerated in this panel's principle on communities of interest. And furthermore, any risk of injecting partisanship into this panel's deliberation does carry the risk that it will be seen less as the nonpartisan body than it is, and more body that must weigh political considerations. And I would suggest that those sorts of...
So then, counsel, how will we assess if in fact the desired goal of, I think, every panel to achieve fair redistricting that doesn't favor or disfavor incumbents or politicians or anything, that is separate and apart, that redistricting is for the voters, it's for the people, not for any candidates. How do we know we're achieving that if we don't consider political data that's relatively available for us?
Certainly, I'd again direct the panel to previous panels' efforts. As has been noted, neither the Zachman panel nor the Hippert panel chose to look at partisan data or figures when they were undertaking redistricting, even though that sort of information would have been available. But the risk there was by the very subjective and partisan nature of considering partisan data might have had the undermining effect of making the panel's decisions actually less political, or at least perceived as being less political. the maps were nonpartisan, not because nonpartisanship was measured and was a specific principle that was enumerated. The maps were nonpartisan because nonpartisan redistricting criteria took priority. And I think by undertaking that same analysis, as the panel did last month, by conducting public hearings, by requiring that parties defend their map submissions, both in terms of the communities of interest it proposes and any deviations from the other redistricting criteria, by conducting oral arguments like this that increase the transparency of these proceedings, these inputs will ensure that the output is a fair and impartial map. By contrast, even the act of determining which criteria and which metrics to use to judge partisanship is, in a sense, a partisan or at least a subjective act. There is disagreement among political scientists and in literature over how best to judge whether or not a map is fair or not, whether it's partisanship, fairness, whether it's proportionality. There are various metrics, and both the inputs and the outputs have a required subjective effect, determining which tools to use, determining, as the Watson plaintiffs propose, what partisan index to choose and which input should go into that, which election results. These are complicated efforts, but problematic not because they're complicated, but because they are subjective and beyond what traditionally judicial redistricting panels have done. And then the outputs themselves, how to measure, what thresholds to choose. At what point does an efficiency gap render a proposed map unduly partisan? Those are the sorts of, again, murky political issues that are probably not only beyond the experience of judicial redistricting panels, but unnecessary, because if the panel relies on its neutral criteria, the result will be fair and impartial maps.
So, counsel, let's go to compactness. Where is that in your principles? Where is it in the hierarchy? And if you think it should be in the hierarchy, what measures should we use? There's hundreds of them. We heard that in the public hearings. There's lots of them. MAP2 uses 11. What are the measures that we should use, if you think it's important to be in the principles?
All of the parties agree that compactness is legitimate redistricting criterion. That much is clear. It is the Sachs plaintiff's position that and whether or not there should be a hierarchy of principles is a matter perhaps I'll address in a moment, but suffice it to say that compactness, if there is a hierarchy, should not be high up. And this gets to a point that was raised with counsel with the secretary, of whether or not compactness is itself a virtuous measure on its own, or whether it is, how much value does it have on its own? And our position is that compactness does not have a lot of value judged on its own. It's best viewed as being a proxy for other redistricting criteria. Because I think the instinct is when we see a district that's oddly shaped or looks a lot like an animal or some other kind of creative line drawing that's done, I think the natural instinct is to ask, what is the kind of insidious or unsavory purpose that might be behind this? Is the district drawn funny to pack or crack a minority community? Is it being done to some sort of partisan effect? But here the panel is already looking at those considerations. It is aiming to draw non-partial maps. It's considering other legitimate and neutral redistricting criteria such that compactness itself isn't doing a lot of work and its utility is reduced. And moreover, to the extent that compactness just exists to, in essence, measure the aesthetic value of a district, whether it's a perfect square or a perfect circle, I think that aesthetic consideration should be subordinated beneath legitimate considerations. Are political subdivision boundaries respected? Are minority groups given the opportunity to elect candidates of their choice? Those are the actual substantive issues that compactness might be helpful to measure. And just to get to the second question as well, the Sachs plaintiffs, like the Secretary, have not taken a strong position on which measures of compactness should be used. There are many of them out there. They might be redundancies and so forth, but that can be happy to address that later if it would be useful. I'll touch briefly on the issue of hierarchies. I know both the Watson plaintiff...
Counsel, before you do that,
yes.
I asked all of the other counsel about your proposal regarding influence districts and coalitions. Did you hear those questions?
I did.
How do coalition districts align with the case, for example, Jingles, which focuses on a single group?
Jingles did focus on a single group, but I believe it's in a footnote to Jingles, the Supreme Court explicitly said it would not be addressing whether or not coalition districts are cognizable under Section 2. And I believe it was in Grove v. Emerson, which obviously a Minnesota case, that same issue came up and that same response was elicited from the court. So while the U.S. Supreme Court has never firmly decided whether coalition districts satisfy Section 2, circuit courts have regularly determined that it does. And we cite in our briefing a recent case from the Eastern District of Virginia, the Holloway v. City of Virginia Beach opinion at the district court, which did a very excellent job of sketching out the landscape and arriving at the conclusion that the vast majority of judicial precedent suggests that coalition districts do satisfy Section 2. And to get to Judge Williamson's question about what is the most sort of important new proposal that the parties are making, I would suggest that more clearly articulating what exactly Section 2 of the Voting Rights Act generally, and the U.S. Constitution protects in terms of minority representation is an important development that the Sachs plaintiffs have proposed. There's no indication, of course, that the Zachman panel, the Hipper panel, or anyone else ignored these issues. But as the minority communities in the state of Minnesota have continued to grow, and as recent years have demonstrated the inequities in that system, more clearly articulating what exactly are the rights of minority voters and how those rights and that representation can best be safeguarded is a legitimate goal and one that the Sachs plaintiffs certainly promote.
Along those lines, talking about opportunity to influence, all right, influence district, would you propose a numeric threshold? How would we be able to identify whether there is a voting age majority of a population that has an opportunity to influence? And whether particular district lines would dilute that effort?
Certainly. We've not proposed a numerical threshold, and I'm not actually certain if there is much of a coalescing among different courts around what that principle or what that threshold might be. But I think a way of addressing that might be to approach it similarly to the issues of communities of interest. You have heard not only from occupational and economic communities of interest, but also from cultural, ethnic, and racial communities of interest as well. To the extent that the panel has heard that input, and to the extent that the parties in their submissions can identify what those communities are and describe in detail how district lines can be drawn to ensure that they have the opportunity to do so, I don't think there is ever exactly one threshold number in terms of what influence level is needed in order to elect a candidate of choice, at least not in this kind of narrower sense of influence districts. But I think that the parties can provide evidence both from the record and also in their submissions to demonstrate where those communities might exist, and then the panel can look at that evidence and determine whether or not district lines are appropriately drawn.
Madam Presiding Judge, can I follow up, please? Who makes up the coalition that you keep making reference to? Who is the coalition? Who makes them up? How do we know it's a coalition?
Certainly, I think if you look at the case law, including especially from the Fifth Circuit, from the 11th Circuit, and then the recent decision I mentioned that kind of sketches this out, under Section 2, coalition districts are widely accepted as being any group of racial, ethnic, or language minority groups that together form a coalition. So it can be essentially no one single group that would otherwise be protected under the Voting Rights Act necessarily hits that 50% threshold, but aggregated a group of minority groups, any one individually which would qualify for Section 2 provisions, aggregated together do clear that 50% threshold. I thank the panel for this opportunity.
We have one more question.
Oh.
Yes, just I'd asked other counsel too. Do you have a position on what the hierarchy of protecting political subdivisions should be? In the last panel, there were actually townships that were split. School districts can be very large, covering many counties. You know, is there any hierarchy of protection of the political subdivisions?
Yes, Your Honor, we have not taken, similar to the previous response, we've not taken a strong position. And indeed, and it's just to briefly touch on whether or not a hierarchy of any sort is appropriate during this process, the Sachs plaintiffs believe it is not. As has been said, difficult decisions are going to have to be made. Marginal lines are going to have to be drawn. And it's important that the panel keep an open and flexible approach to ensure that whatever decision is made is both context and fact specific, and ensures fair representation for all Minnesotans. So whether that might involve dividing a county line versus a municipal township line, I don't think favoring one over the other as a proactive measure is necessarily helpful. I think it will ultimately come down to each individual case-specific inquiry.
All right, and do you believe that the Indian reservations deserve a status almost on their own, not being a political subdivision as such?
We do, and we think this is illustrative of the Sachs plaintiffs' overall approach, which is to respect what the Hippert and Zachman panels did, and only to make marginal changes where needed to better give life and to give credence to what they did. So if you read those panels didn't adopt the preservation of American Indian reservations as a specific enumerated principle, but if you look at the orders where they adopted their congressional and legislative plans, it's clear that they went to great pains to ensure that they did. And we believe that treating, for the reasons that have already been discussed, treating Native American reservations as political subdivisions is inappropriate just as a legal matter of sovereign governments, but that is exactly the sort of issue that we think should be made its own separate principle. It's consistent with past practices, but ensures that the panel's principles best reflect what those best practices have been over the years. Thank you.
We will now hear from the Corey plaintiffs.
Good afternoon, Your Honors. May it please the Court. My name is Amy Erickson, and myself, along with my colleague Brian Dillon, represent the Corey plaintiffs in this action. As the panel is aware, the Corey plaintiffs intervened in this action to ensure that the rights and interests of Black, Indigenous, and all Minnesotans of color, or Minnesota's BIPOC communities, are adequately represented in this redistricting process. As was presented in greater detail in our intervention complaint, as well as our briefing on the redistricting principles, BIPOC communities currently represent 21.4% of Minnesota's population, an increase in more than 4% since the 2010 census. It's also important to recognize that during the last decade, approximately 85% of Minnesota's population growth has been among BIPOC communities. In light of these statistics, it's more important than ever that Minnesota's BIPOC communities are given a seat at the table in the redistricting process and recognized in the redistricting principles. The principles that will guide this redistricting process should in particular emphasize the importance of preserving communities of interest and ensure that BIPOC Minnesotans will have equal opportunity to influence elections consistent with the 14th and 15th Amendment as well as the Voting Rights Act.
Counsel, I'm going to jump in and ask, do you agree with Mr. Hawley on his definition of what makes up a coalition based on what he just said?
Yes, Your Honor, we do agree with that definition.
Do you believe that Jingles supports your definition of this proposed principle?
Yes, Your Honor.
How so?
Oh, excuse me.
That's all right, just how so? Go right ahead.
The language in our proposed principle does in fact come from the Jingles case.
Tell us also the legal authority for requiring us to create an influence district.
I would point the court to the case law, including Jingles, which discusses influence districts in part. The case law on the Voting Rights Act, and I apologize, I don't have the precise citations in front of me, but does discuss influence districts both in connection with Section 2 of the Voting Rights Act as well as in connection with Section 5 of the Voting Rights Act. And I would just emphasize, as I just mentioned, Minnesota's BIPOC communities have grown more than ever, and the reason that we think that the expanded language should be included this year with respect to the 14th and 15th Amendment and the Voting Rights Act is to ensure that those BIPOC communities are adequately represented in the redistricting process.
One last follow-up to that is Presiding Judge Berkman asked about a numerical threshold. Do you believe there is a numerical threshold? Like what creates this coalition or this influence? How do we know that?
Your Honor, I don't believe that there's a precise numerical threshold. I believe that it would be incumbent on the parties to describe to the panel in connection with the memorandum that would be submitted in connection with our maps why, what the coalition districts are and what the threshold should be with respect to that particular coalition district. I'd like to go back to talking a little bit about communities of interest, as we think that that is one of the most important principles that the panel should expand on in this redistricting cycle. The Corey plaintiffs have proposed a redistricting principle on communities of interest that requires communities of interest to be respected to the maximum extent possible. And for purposes of this principle, we have stated that it should include racial, ethnic, linguistic groups, or any group with shared experiences. We've specifically enumerated some of those shared experiences, but we don't believe that the list should be limited.
I'd like to ask you what you mean by to the maximum extent possible. And I know you've suggested in your submissions that communities of interest should be given higher priority than, say, political subdivisions or convenience contiguity. What would be the authority for that?
That's correct, Your Honor. We have said that they should be respected to the maximum extent possible. And I think, of course, when we say to the maximum extent possible, what we mean is that consistent with the other constitutional and statutory principles that we're talking about here today. The Corey plaintiffs haven't identified a specific hierarchy of principles. We believe that, there are numerous constitutional principles and statutory principles. One is not necessarily more important to the other, but we believe that it's incumbent on this panel to balance those principles against each other. I'm not sure I've precisely answered your question, Your Honor, so I'm happy to address another question if you have one. Okay, thank you.
Counsel, if I can follow up just a little bit, with respect to legislative principles, if I understand the argument in your brief, you acknowledge that de minimis deviation is a goal, but you would allow for deviation from an ideal so long as it is based, and I'm trying to quote, that's why I'm looking down, based on a legitimate consideration incident to the effectuation of rational state policy. So, reading your brief as a whole, are you suggesting communities of interest? Is that what you mean by legitimate considerations, or do you mean something else?
That may be one legitimate consideration, Your Honor. Our proposed language on the maximum deviation for legislative districts comes directly from the case law that we've cited in our brief. I'll note that, I don't anticipate the parties submitting, including ourselves, a map that would drastically vary from the 2% principle that this panel has adopted in the past. With that said, I think that the case law on this issue gives the parties an opportunity to present certain circumstances under which a deviation from that past used 2% principle should be used. And one of those may be the importance of recognizing a community of interest in a particular map.
So when you talk about effectuating rational state policy, are we really talking about other redistricting principles?
I think in the context of what this panel will be addressing, Your Honor, yes, we would be mostly looking towards the other redistricting principles.
Counsel, we had asked other attorneys, but what is your position on the constitutionality of the existing lines as drawn, and is it immediately ripe for a determination that it's unconstitutional?
We could mince words here a little bit, Your Honor, and I don't know if we would go so far as to say that the current districts are unconstitutional as they stand, but what I would tell this panel is that if this panel were to adopt the current maps as the maps at the end of this process, those maps would of course be unconstitutional. And that goes back to what our clients have been highlighting, which is in particular the growth in Minnesota's BIPOC communities. There need to be adjustments to the maps that come out of this redistricting cycle in order to account for those population changes in Minnesota.
All right. Do you agree that the panel owes some deference to the legislature, at least until February 15 of 2022?
Yes, Your Honor, I do.
Thank you.
One other thing I'd like to comment on, Your Honors, is something that's been repeatedly raised by the Anderson plaintiffs. Throughout their submissions, one of the things that they've argued is that this panel shouldn't deviate from the principles established by the Hibbert panel a decade ago. And in support of this position, they've contended that the prior principles must be sufficient because no party has alleged that the maps adopted by the Hibbert panel were unconstitutional then. They note specifically, for example, that no party has alleged that the prior districts drawn were insufficiently competitive or unduly favored one party. This argument is flawed for a number of reasons. First, the maps adopted by the Hibbert panel were based on census data that was collected over a decade ago. So while the Hibbert maps may not have been unconstitutional a decade ago, as I just noted, they would be today. I think it's also important to note that this panel should be identifying redistricting principles that are appropriate for this cycle in light of the current circumstances and population changes in Minnesota.
Should they have a principle to keep the boundaries in place all rights?
Yes, Your Honor. The Corey plaintiff's position is that American Indian reservations deserve a separate principle to keep those boundaries intact, in part in recognition of the sovereign authority of those American Indian reservations.
You also raised the issue of reallocation of prisoners. That's a unique position among the parties. We know that the census data did not give us what the reallocation is. And there's a stipulation among the parties that we're going to rely on census data. So what authority do we have to look at reallocation of prisoners?
I acknowledge, Your Honor, that looking at reallocation of prisoners in connection with this panel's work may be a challenging task. What I would say is that this is an issue that impacts minority and BIPOC communities in Minnesota in particular. As such, it's important to my clients. And I think that if there's a way that we can show what those current addresses are and how that should change the data, that we should be allowed to present that information.
At the time of presenting?
That's correct, Your Honor.
I want to just clarify a statement you made a bit ago. I think you suggested that the changes in population that we've experienced in Minnesota over the last 10 years, particularly the population growth in the BIPOC community, that those changes should persuade this panel to adopt new redistricting principles. And I'm not sure, I mean, I understand how population changes where district lines go, but why would you say that simply changes in population growth and population growth among certain communities should affect the principles we apply?
Thank you, Your Honor. I think you made an important point, which is that the population changes in Minnesota are going to have a significant impact on what this cycle's maps look like and what the map this panel issues at the end of this process. Because the population changes need to have an impact on maps, when we're talking about the principles, we need to talk about how we factor in the population changes, in particular the growth among Minnesota's BIPOC communities. And I think, this goes to our two primary principles that we think this panel needs to consider this year, which are changes to the communities of interest principle and changes to the minority voting rights principle, or the principle on the 14th and 15th Amendment and the Voting Rights Act. With respect to the communities of interest principle in particular, I think it's important to understand that the preservation of communities of interest is important because it protects in part against improper gerrymandering, and it can help ensure that historically underrepresented groups in Minnesota are adequately represented going forward. And in particular, I'll explain it this way. If a community of interest is divided rather than preserved, then the consequence is that that community of interest power is diluted in the redistricting process. On the other hand, if a community of interest is preserved, then those communities are able to elect candidates of their choice who will in turn adequately represent their interests.
Communities of interest have been a long traditional redistricting principle. So I think what you're really suggesting is that is a principle that should be higher in the hierarchy. Is that, or take priority over other principles? Is that really what you're arguing? Because communities of interest are a traditional redistricting principle.
Correct, Your Honor, and I think that's why we've used the language that communities of interest should be respected to the maximum extent possible. Certainly, we acknowledge that communities of interest can't be, respected to the extent or preserved to the extent that it might violate a constitutional principle. But with that exception, we think that this panel's work should focus on preserving communities of interest.
But Council, you agree, I think, that political interest is not a community of interest. Isn't that right?
That's correct, Your Honor.
But besides that, your list of what would make a community of interest is exhaustive?
Yes, Your Honor. We have included exhaustive language in our community of interest principle. I guess I would note that we've included, in terms of what communities of interest shall not include, we've included political parties, incumbents, and candidates as well.
But you do support partisan fairness reports or measures.
That's,
How do we square the not including shared political interests as a community of interest with your request to consider partisan data?
with respect to partisanship, Your Honor, I think it's important to note that the Sachs plaintiffs and the Anderson plaintiffs have argued that our proposed principle injects inappropriate partisan criteria into this process. But I think that what we're saying, we're not injecting partisan criteria into the process. What we're saying, and it's certainly not an attempt to shift the playing field towards one party or another, what we're saying is that we want to prevent any attempts at maps that inappropriately favor or disfavor a particular political party. I mean, our position is that our principle is party neutral.
Right, since we have a moment, I had asked other council, do you have any position concerning whether there's a hierarchy on the subdivisions that would be protected? Whether it's townships, if they have to be split, is that something that would be a very low priority item? Is it more important to keep a very large school district together, counties, cities? Is there any hierarchy that the panel should consider on that?
Your Honor, we don't have a specific hierarchy that we would propose to the panel. I would say again that it would be incumbent on the parties to explain why a particular political subdivision should be split and to present the reasons why.
All right, thank you.
Thank you.
Thank you, Your Honors. I keep hearing this phrase that we don't want to inject politics or partisanship into this process. This is a partisan process. This is a political process. The court is just doing it.
Counsel, before you discuss the partisan process, I want to make sure I ask you a question that I have based on your submissions. So you argue in favor of a principle that preserves political subdivisions like counties and cities, but you are a bit unique in that you also reference precincts. One of the arguments raised in the briefing is that Minnesota law expressly contemplates that precincts be redrawn following statewide redistricting. So why would we seek to include precincts within political subdivisions?
Well, Your Honor, precincts are drawn at the local level. They're drawn by local officials for elections, and these local officials know the area. They know the lay of the land. They know the main roads, the waterways, the bridges, the boundaries. And if this panel can use these precincts in drawing its maps, it's going to make your job a lot easier. And after Hippert, there were 28 corrections to the maps that were ordered by the redistricting panel. These were misplaced census blocks. There was a drainage ditch that they thought was a road. And that's not going to happen with precinct boundaries because you have local people with intimate knowledge of the area drawing these boundaries. So we just, quite frankly, think that there is just immense value in the panel preserving these boundaries to draw lines that are in places that make the most sense, for lack of a better way to say it. And I understand that these lines are going to be redrawn after the redistricting is done here with this panel, but that doesn't negate the usefulness of this tool. And old precincts are often used in elections, and so while that they may be redrawn, they can be reused, and oftentimes are, and there won't be little gaps in between them that require a wholesale drawing. So the Watson plaintiffs just believe there's a lot of value that the panel can get out of reusing these precincts or drawing around these precinct boundaries. So again, back to I had said or started with that, I keep hearing this phrase, injecting partisanship. This is a partisanship process, and I hear this word about these phrases that it's controversial and unnecessary, but they don't say how. How is it controversial, and how will this panel lose public confidence by opening the party's plans up to the public, the reality of what's in them and what they do? The Watson plaintiffs just believe that transparency will make the public have more confidence in this process. We don't want to hide the partisanship of the party's plans. We want the people to see it. And quite frankly, the only people that are opposed to this are the political parties. And we just want to check their ability to draw partisan maps. And
Let me ask you this. I mean, I don't think anyone is making the claim that the prior redistricting panels have injected partisanship into their map drawing. I don't think that's been. Why then wouldn't we hew to the same neutral redistricting principles that the prior panels have done? Why wouldn't we achieve the same results?
Well, I 100% agree that we have never claimed and do not believe that any panel has intentionally manipulated boundaries. We certainly don't believe that this panel would do that. But this panel is going to be relying on maps that are submitted by the parties to this case. And if they're going to rely on those maps and they're going to use those boundaries to draw their maps, they should know what's in them. And so we just feel it's another piece of evidence. Courts are asked to review and weigh evidence every day in the courts in this state. And we believe that this panel is more than fit to apply this partisanship information in a fair and neutral manner in a way that is best for every person in this state. Talking about the lease change issue, the Watson plaintiffs agree that maps, boundaries, should be lease change. We just feel that the Anderson plaintiffs have kind of stretched that principle to redistricting principles. So no panel has ever said that redistricting criteria should be lease change. That's never been announced. And I think the Hippert panel is, actually, no, they are unique to prior redistricting panels. I mean, there's the Behrens panel, the Kotlow, I'm probably not saying that, or Lacombe, I'm sorry, they made significant changes to the Behrens panels. And Kotlow made significant changes to Lacombe, and Zachman made significant changes to Kotlow. Hippert was unique in not really changing with the times. So I think, I look at Hippert as more of an outlier than I do as the way that this panel should look at this process. I think other panels have changed with the times. And right now, partisanship, all you got to do is turn on the TV. Partisanship is a huge issue, and everyone is fully aware of it, and it was a hot topic at the hearings in this case. People want this panel to look at this and make sure that you're checking us parties' ability to submit maps that are unfair. Thank you, Your Honors.
Thank you. Ms. Braum, you may proceed.
Thank you, Your Honors. I think I'd like to start with the idea that principles are not the same as facts. The Anderson plaintiffs are not here to suggest that the parties can't offer data in support of their plans or in contesting each other's plans based on any particular item they think is relevant to the panel's consideration. To the extent we've had and heard today conversations about preserving communities of interest or partisan groups, we're not suggesting that a party can't make claims about another party's maps. What we are suggesting is that the issues in principles, or the principles that the panel is being asked to consider, have been addressed by panels in the past in many respects. Partisanship came before the Zachman panel. The issue of minority representation and how to include that in the principles themselves came before the Zachman panel. And the same is true of how to deal with political subdivisions and similar data. Each of these issues was before the panel and considered in depth, not because they were not as relevant as they are today. They were as relevant as they are today. But what the panels have done is crafted criteria that are flexible enough and give guidance to the parties to allow them to draw maps that can be judged based on objective and neutral criteria as we've advocated. Sure, a couple of ways. First of all, it's not correct to say that Hippert was unique. The reason that the Hippert panel followed what Zachman did is Zachman was one of the first panels to have to create maps as a panel wholly from scratch, not because they were dealing with maps that have been addressed by others. So they were thinking about those issues all along the way. Second of all, we already have a criteria that speaks to making sure that we're not unduly favoring incumbents of one party or the other. The third is that I know, because I've worked with Maptitude for 20 plus years, that data exists in Maptitude. We're not suggesting it doesn't. What we are suggesting is that it should not be adopted as a specific criteria on which to judge maps, because that information then elevates the partisanship of the entire process. And the Zachman panel specifically addressed the idea of adopting criteria regarding the preservation of prior cores, the recognition of prior districts as community of interest, or the goal of ensuring that politically competitive districts will result. They rejected all of those concepts because it elevates that issue in the overall consideration of maps, as opposed to just making it a data point or something that the panel might be able to consider along the way, whether it's respect to the party's maps or any map that the panel itself might draw. I think it's also important to note that to the extent the Watson plaintiffs or others suggest that there are only two parties with political goals here, I think it's probably pretty unfair to say that. The panel can look at any of the parties and see where the plaintiffs are from, how things have evolved in this process. And so this, again, is not new. This is something that has been before panels for decades, not even the last 20 years, but 30, 40, 50 years before that. And so it's not correct to say that because there are parties here who are being clear about where their allegiances lie, that they are somehow planning to or trying to overly inject partisanship into the process, or that those are the only parties that have political interests. So I think it's just important to be clear about where we are coming from on this particular issue. Second, I'd like to address the issue of the communities of interest and minority interests with respect to the different districts that or criteria that might be before the panel. The question is for the panel is not just one of preserving communities of interest or not preserving communities of interest, because the goal of preserving communities of interest can also grow to the point where, in the name of preserving a community of interest, inadvertently the result is that parties have less opportunity, or a group or a coalition has less opportunity to have an influence in multiple districts because they are so withheld or crammed into one particular district. Those are exactly the kinds of concerns on both sides of that equation that past panels in the United States Supreme Court have been very careful to say, when a panel of judges sticks to neutral and objective redistricting criteria, then there is less concern about those things happening inadvertently. Because what you are focused on is the neutral criteria and the natural choices that people make about where to live, the political subdivisions they're in, and so on, are all effectively joined or all effectively taken into account in ultimately the drawing of the maps. And I think it's also important to note that in the United States Supreme Court case of Bartlett versus Strickland, it was specifically noted that the Voting Rights Act does not require the creation of an influence district in order to influence the outcome of an election. This does not mean that the panel, that Anderson plaintiffs are in any way suggesting that minority interests should not be taken into account. We absolutely believe they should. It's just a question of how deeply this panel wants to change and potentially drive outcomes that may have unintended consequences based on assumptions about how different groups of people do or do not vote as a coalition. Thank you.
Thank you. I'd like to briefly address Judge Bratvold's question about precincts and then address some of the discussion about constitutionality of the current districts. As to precincts, the Secretary of State had included that as well, and he does so from the perspective of election administration. And this isn't new. In Zachman, in the legislative plan, the court or the panel specifically identified how many precinct splits were created and noted an effort to avoid that. And to some extent, this is tied up with preserving political subdivisions. Precincts cannot span a legislative district or city or town. So to the extent the panel is faced with some tough decisions, I suggest looking at the precincts, because when more precincts have to be created because of splits, that is adding burden on election administrators, more equipment, more staff. It can create voter confusion. So that is why precincts are an important consideration. But as the Watson plaintiffs noted, of course, they are drawn after the maps are created. Turning to the constitutionality, there's no doubt we need new maps, but we need new maps for the 2022 primary and general elections. No constitutional violation would occur unless they were used there, and this entire process is designed to avert that violation. That's reflected in our state constitution, that the Senate, there's a new election after redistricting occurs, after the apportionment. Even at the February 15th date, certainly it is ripe for this court to make the decision, but it's still not a constitutional switch that it's suddenly the current districts are unconstitutional there. And that's reflected in the actual relief in the Hippert panels. At the end of the decision, the injunction was as to the primary and the general elections in 2022. And as noted in the Secretary's briefing, the reason is it would inject chaos if there's a violation of a constitutional violation. There can be special elections. There have been some in each of the past two redistricting cycles, so that would create quite the quandary in terms of how do we hold an election. So ask the court, if the legislature does not enact a plan by February 15th and this panel has to adopt a map, that it carefully craft the relief as the Hippert panel did. Unless there are no further questions. Thank you.
Thank you, Your Honors. Unless the panel has any specific questions, I'd like to begin with an illustrative example from 10 years ago that I think captures some of the issues we've been talking about and demonstrates how they actually occur in practice. So when the Hippert panel was drawing its congressional map 10 years ago, it needed to split Stearns County. And in doing so, it decided to put the western part of Stearns County, which is primarily agricultural, in the more agricultural and rural 7th district, whereas the city of St. Cloud, which is more semi-rural and has more suburban type characteristics, was placed with the 6th district, which reflected that particular community of interest. I think it's a very good example because I think there are a few things that were going on there that can help inform how this panel should balance these various considerations and put them into practice. Number one, it demonstrates how, despite the talk of communities of interest being particularly subjective, it's not hard to be able to look at groups of people in the industries that are important to them and see something like how an agricultural community of interest might exist in a given area, how people coalesce around their jobs in certain industries, and how that's something that might lend their need to have representation, whether it's in this building or in Washington, D.C., to be reactive and responsive to those issues. Number two, it demonstrates how that balancing process should take place. In that case, the need to divide a political subdivision was apparent because of the issues of population equality, and the panel chose to split the county while preserving the city of St. Cloud, which I think gets to Judge Carlson's question about how do we deal with these different political subdivisions. In that case, the panel was able to use community of interest and looking at how St. Cloud interacted with the areas around it to make the best determination of how to make that division, which again gets to this idea of balance. No hierarchy is necessarily needed because in those kinds of case-specific instances, the panel is able to look at the evidence in the record and the submissions of the parties and make a determination. When the difficult choices have to be made, the evidence will be there to help guide the panel to do it best. And that decision can be informed by these principles that we have been suggesting. I think if the Sachs plaintiffs leave here with one thing, it's to give a certain guiding precept to this panel. Earlier, the question was asked of one of the Watson plaintiffs' proposals, what ill is trying to be remedied here? And I think that's an excellent attitude when it comes to whether and how to depart from previous redistricting principles. Simply put, if it's not broken, it doesn't need to be fixed. And ultimately, I think all of the parties here would agree that judicial redistricting in Minnesota is not broken. Previous panels have adopted principles with variations and produced maps that fairly and accurately reflected the partisan makeup of the state, helped preserve communities of interest, and ensured an overall fair and impartial map. The Sachs plaintiffs believe that our proposed principles capture the middle ground between either excessive inflexibility on one hand or significant departures on the other. We do not believe that this panel needs to unnecessarily depart from previous panels' principles, only to do so when necessary, again, to ensure that the principles reflect what works best in practice. For example, creating a new principle to preserve American Indian reservations, subordinating compactness as a less useful measure of the fairness and the impartiality of a map, and enunciating more clearly the specific protections afforded by the Voting Rights Act and the U.S. Constitution. These departures are necessary, but wholesale departure is not, because previous panels have done their job well, and they've provided a groundwork upon which this panel can build, both in terms of the principles they adopted and how they chose to apply them. And
so, Counsel, you just identified 3 changes that you think are significant, and you're hoping that the panel will adopt all 3. If you had to choose one of them, which one would you choose and why?
I would only say, first, Your Honor, that I would not necessarily consider those significant in the sense that we're not asking this panel to do anything, in effect, that previous panels have not. They're significant only in that the language that we've chosen better reflects what those are. But as I mentioned earlier, I think giving voice to the specific parameters and protections afforded to the state's minority communities is an important, if not a significant departure, certainly an important principle that this panel should adopt. And it captures the same spirit of communities of interest and other issues that we've been dealing with. This state has changed over the past 10 years. The way people live and work, the communities they form, the shared values that they have. This panel is uniquely situated through public hearings and the party's submission to look at those different interests and those different needs and to draw maps that will ensure that all Minnesotans have fair and effective representation in the legislature and in Congress. And the Sachs plaintiffs believe that the middle ground that we've charted, departing only where necessary to give life to principles, but maintaining what has worked so well in the past, is the best way to achieve that. Thank you.
Although the parties have quibbled about a lot of things today, I think it's important to reiterate to this panel that there's a lot that we agree on. If not with respect to the precise language that's in the principles, at least in principle. We agree that congressional districts shall be nearly equal in population as possible. We agree that congressional and legislative districts shall consist of convenient, contiguous territory. We agree that congressional and legislative districts shall be structured into compact units. We agree that federally recognized American Indian reservations shall not be divided into more than one district, except to meet constitutional requirements. Most of the parties agree on the numbering of the legislative districts. Most of the parties also agree that political subdivisions shall not be divided more than necessary to meet constitutional requirements, form districts that are composed of convenient, contiguous territory, or preserve communities of interest. And most of the parties agree that congressional and legislative districts shall not be drawn for the purpose of or effect of promoting, protecting, or defeating a candidate, incumbent, or party. In the course of this panel's work, you have already heard from and will hear from more communities of interest who have asked that their communities be respected or preserved in this process. These communities of interest include the Latino community in southwestern Minnesota, who are the backbone of Minnesota's agriculture industry, African communities in the northwest suburbs, namely Brooklyn Park and Brooklyn Center, who share markets, places of worship, and schools, and have shared concerns about affordable housing. That also includes the deaf and the deafblind community in St. Paul, which is centered around the Metro Deaf School, Deaf Equity, and numerous other community resources for deaf and deafblind individuals, and the Hmong community in Brooklyn Park and Brooklyn Center, who rely on various shopping centers and other shared community resources. These communities of interest have asked to be respected in the redistricting process to ensure that their community power is not diluted, and that they instead have the opportunity to elect candidates of their choice and to elect candidates who will represent their interests in the legislature and in Congress. Our clients ask that these communities of interest be afforded the most respect possible in this redistricting process. And again, I would ask that this panel adopt the Corey plaintiffs' proposed principle on communities of interest. I also want to address a couple of things that were raised by other parties today. The first thing is this idea of the least change principle. This is something that the Corey plaintiffs addressed in their briefing, but I want to emphasize that it's our belief that the least change principle should not apply either to this panel's adoption of the principles or to this panel's adoption of the boundaries. And I say that because this panel's task is to adopt boundaries and principles that reflect the state of Minnesota today. And it shouldn't be constrained by an arbitrary least change principle. It should instead evaluate the maps that are presented by the parties and the principles that are presented by the parties, and evaluate what best reflects the Minnesota that we're looking at today, including the extreme growth in Minnesota's BIPOC communities. If the panel doesn't have any other questions, I would just respectfully ask that you adopt the Corey plaintiffs' proposed principles. Thank you.
And I think we have heard from everyone 2 times. I want to thank all of the council. This argument was very helpful. I appreciate your preparation, the written submissions. We really do appreciate it, and will aid the panel in its work. So with that, we will take the issue of redistricting principles and preliminary issues under advisement, and we'll issue an order in due time. Thank you.